former public protector, Advocate Busisiwe Mkhwebane, is in the High Court in Pretoria today to challenge the decision by the Office of the Public Protector not to pay out her multi-million rand gratuity. It's a virtual sitting and has begun. Let's listen in.
Under Rule 53(1)(b) for the production of the record. And if there is default for the production of the record, the rule itself says Rule 6 applies mutatis mutandis. So that would then entitle the applicant to compel the production of the record. So that has not happened, which is not a default on our side. The application to compel if the record has not been provided. That's number one. So you don't have the record. Number two, under Rule 53, sub-Rule 4, the applicant is entitled, after the production of the record, to indicate by notice whether or not they stand by the notice of motion or they want to amend the notice of motion. Now, they may waive their entitlement to the record because your ladyship was in fact involved in a case that I argued and lost, where the principle was reaffirmed that the right to the record is for the benefit of the applicant, and the applicant may waive their entitlement to the record. So if today they have waived their entitlement to the record, they are still obliged to comply with Rule 53(4), which is to indicate by notice whether they wish to amend their notice of motion or whether they want to stand by the notice of motion. They have not done that. Number three, in paragraph 50 of the founding affidavit, they indicate their desire for this case to be case managed for a special allocation. This is not a special allocation. This is a normal urgent motion rule. So for those three reasons, the case is in fact not properly enrolled, not by us, but by the applicant. There is obviously the fourth overriding issue, that the case is not urgent, is improperly enrolled as an urgent application in the urgent court when it is not urgent. So
let me just find out your answer affidavits. It's not on case lines. I received it only last night.
Yes, it's
not complying with the court directive.
Yes, my attorney told me that it was not on case lines for the reason that the system was down when they tried to upload it, but they did put it on case online, which apparently are different instruments. So what has happened with that is that because the applicant was refusing to remove the matter for a special allocation, we decided that it was prudent to put the full answering affidavit so that if the matter has to be heard this week, the case at least is fully pleaded on our side. So that is why it is in. And it is also accompanied by a full founding affidavit for condonation. So we didn't just dump it. We put in a condonation application in which we also deal with the issue of the special allocation. And obviously, we have said in our practice directive, a practice note, that Rule 53 has not been complied with. So from our side, the matter is fully pleaded. We have no further pleadings to file. So if the case is to proceed, as the applicant seems to be intent, we will oppose the case both on urgency and on the merits. Obviously, it will mean that the applicant is waiving their right to the record and they are waiving their right to file a reply. We filed heads of argument, so we are completely ready to argue the case today. We do say to your ladyship that you should nevertheless simply remove the matter with no costs for a special motion, which is the more prudent thing to do. But if you don't remove the matter, then we are ready to argue it.
All right. And the cost?
Well,
if I were to do that?
You should compel the applicant to pay the costs. They are the ones who improperly enrolled the matter in circumstances where they knew that there had not been compliance with Rule 54. They are also the ones who enrolled the matter when they knew that it was not urgent. They are also the ones who enrolled the matter when they knew that they had asked for a special allocation and this is not a special allocation. So it's the applicants who have forced all of us to be here today with absolutely no reason, when the matter could have been handled maturely between the council, that it should go to special motion. So there's no question of the Public Protector's Office paying the costs of a reckless set down by Mrs. Mkhwebane.
Thank you, lady.
Council, just a few minutes. Since Judge Collis is having an issue with her connectivity, we'll proceed shortly.
Okay, thank you.
So apologies for that. As you might have heard, it seems that Judge Colleen Collis has some issues with her connectivity. And I suppose this is what comes with having virtual sittings of these type of matters. But what we've been able to hear so far is Advocate Mkhwebane, SC, representing the Public Protector's Office, actually questioning the enrolling of this matter on a technical basis. In fact, it sounds like, at least insofar as his argument is concerned, that the Public Protector or Busisiwe Mkhwebane's legal team didn't enroll this matter correctly. That's at least the argument from Gauteng. And he reckons that because of that, it should be re-enrolled, or if they want to proceed, they can, but apparently she waives some of her other constitutionally enshrined rights. So it's an interesting, convoluted start to what seems like is going to be a very complex sitting of this particular matter. As soon as some of those technical gremlins are issued or ironed out, we'll make sure to be back for you and continue listening in on this virtual sitting.